thank you for having me. Thank you for coming. I'm not sure I can live up to the build-up, but I'll do my best. We're going to talk about all things Supreme Court from the past term. Well, at the end, we'll talk a little bit about some of the cases that are coming up this term, but we're going to focus on last term. And also, we're going to start by we're going to give like a quick review of the history of the Supreme Court to kind of help understand how we got to where we are now. So the Warren Court era, everybody who went to law school probably remembers talking about the Warren Court, right? The Warren Court it always had at least 5, but a lot of the time 6, and sometimes, depending on how you count it, maybe 7 staunch left-leaning justices. So it was a court that had a solid liberal majority. Even when it had just 5, they were 5 solid liberal justices. So it was not a swing court, right? There was no justice that was a swing justice going back and forth, side to side. Just a solid liberal-leaning court. In fact, Nixon in 1968 ran hard against the liberal Warren Court, right? In fact, the liberal Supreme Court, or the liberal court in general, that whole concept really starts with Nixon running hard against the Warren Court. They've continued to push that message for the past 50 years, but it really kind of ended with the Warren Court. What happened is in 1968, Chief Justice Warren announced that he was going to step down. It was an election year. He wanted LBJ to be able to appoint his replacement before leaving office in case LBJ lost the election LBJ. In 1968. Then LBJ announced he wasn't going to run again, right? But before all of that, Warren announces he's going to retire so that LBJ can appoint his replacement before the election, and the Republicans go nuts about it. And so they basically try to sort of block that. And he wants to, LBJ announces he's going to appoint Abe Fortas, who's already a justice, as the new Chief Justice to take Warren's place. And so one of the things that the Republicans do to sort of stop what's happening is they start aiming their guns at Fortas. And they end up turning up some real scandalous material. Like there were some financial things that were not great. There was also, it came to light that Fortas had kind of been consulting with LBJ from his seat on the Supreme Court. So there was some real concern. So Fortas ends up having to resign. Actually, the election happens. LBJ announces he's not running again. Then, Bobby Kennedy gets assassinated, all that kind of stuff. Nixon gets elected. Fortas is forced to resign from the Supreme Court because of the ethical scandals surrounding him. Warren stays true to his announcement of retiring. So now Nixon gets elected and immediately has 2 vacancies on the Supreme Court to fill. He fills those 2 vacancies, and a year later, 2 of the other justices on the former Warren Court die within a month of each other. So he gets 2 more vacancies. So in 2 years, Nixon gets 4 vacancies that he fills on the Supreme Court in 2 years' time. And we no longer have anything resembling the Warren Court. We now have the Burger Court. And there's a 5-justice Republican-appointed or conservative-leaning majority. But what happens in the 1970s is we get the emergence of this concept of the swing justice. So Justice Powell on the new Burger Court kind of emerges in the mid to late 70s as this swing justice who doesn't always vote down the line with the conservatives on the Burger Court. Then in 1981, I think it is, President Reagan appoints Justice O'Connor. She's the first woman justice on the court. She kind of takes over the role as the swing justice. So she's a little more conservative than Powell was. Powell and the other conservatives appointed by Nixon, they're the 1970s style conservatives. They're not it's a little different style of conservative than what we have now. But O'Connor is a little more conservative than the others, but she still is a swing justice. So the center of the court moves a little bit to the right, but we still have this swing justice in the middle with Justice O'Connor who will go both ways sometimes depending on what the issue is or what the case is. In the 1980s, President Reagan appoints Justice Rehnquist as the new Chief Justice when Berger leaves. And then he also appoints Justice Scalia and Justice Kennedy. this sort of solidifies the 5 conservative majority, but O'Connor is still the swing justice. And then heading into the 90s, we get Justice Souter and Justice Thomas from Bush Sr. But the balance of the court stays pretty much the same. O'Connor leaves in like 2001, maybe, and Kennedy, who is a little more conservative than O'Connor, takes over as the new swing justice. He still votes with the conservatives about 60% of the time, but he's voting with the liberals on sort of key divided cases maybe about 40% of the time. But again, he's a little more conservative than O'Connor, so the center of the court, again, shifts a little more to the right again, but we still have a swing justice. There's still a balance on the court. And then in 2016, as most of you remember, I think it was February, maybe, when we got the news that Justice Scalia had died. Now, that happens when President Obama is in office. This is earth-shaking, right? Because since the early 70s, we've had a 5-justice conservative majority on the Supreme Court with a swing justice, but still 5-justice majority of conservatives. And now President Obama's in office and Justice Scalia dies. That opens up the potential for appointing a left-leaning justice that would shift the majority. We still would have a swing justice. Kennedy would still be there, but the majority would now be left-leaning justices. That's exactly why the Republicans pulled out all the stops to block Obama from appointing Judge Garland as the new justice to replace Justice Scalia. So they blocked that nomination for almost a year. Trump gets elected president, and then when Trump comes into office, instead of Judge Garland, we get Justice Gorsuch to replace Justice Scalia. So the balance of the court doesn't shift, but Gorsuch is actually a lot like Scalia in a lot of ways. So the balance of the court doesn't shift, but that window of opportunity for changing the dynamic at the court closes. And then Trump goes on to appoint, we enter this era where Kennedy, who's been the swing justice now for, 10, 15 years, probably 15 years, Kennedy announces his retirement while Trump is president. Trump appoints Justice Kavanaugh to replace him. Now we no longer, that is the end of the swing justice era. When Kennedy leaves the court, we no longer have a true swing justice. We have Kavanaugh and Chief Justice Roberts, who are in the middle. They are at the center of the court, but they're not swingers. Like they're voting with the conservatives. They're voting with the conservatives 95% of the time. All right, they're not swinging to the other side hardly ever, but they are at the middle. They're the more moderate conservatives, so to speak. So the center of the court now has shifted further to the right, and now there are this is Warren Court territory because we have 5 solid conservatives on the court in the majority instead of a swing. And then, just as we all know, Justice Ginsburg in 2020, not long before the election, it's like 2 months maybe-ish before the election, Justice Ginsburg dies. Suddenly, it's okay to appoint replacements in an election year. And the Republicans go ahead and appoint, they had blocked President Obama's attempts to appoint a replacement during an election year for almost a year. They take about, I think it's like 6 or 8 weeks to appoint Amy Coney Barrett as the replacement for Justice Ginsburg. So she takes Ginsburg's place, and now we have 6 staunch conservatives on the court, and we're in Warren Court territory only for the right instead of for the left. So the swing justice era is gone. We have this new Roberts Court era. This is the first term, the term that ended back in July, the one we're going to talk about today. It's the first term with the full new Roberts Court on the court because Barrett, her confirmation went a few weeks into the previous term, so there were some cases she missed out on. So this is the first full term we've had with the new Roberts Court, with this new 6-justice majority that can do essentially anything they want because they only have 3 liberals in the minority who can't do anything about it. Over this past year, we've seen the approval ratings for the court sort of take a nosedive. There's been a lot of talk about court reform, term limits, adding justices. A lot of talk about the Scalia seat being stolen by the Republicans, all that kind of stuff. Lots of talk about all that kind of stuff. I'm going to tell you, I don't think any of that's going to happen. They're not going to add justices. They're probably not going to impose term limits. Whether you think they should or not, it's just probably not going to happen. Congress isn't great about actually doing anything, so it's probably not going to happen. But there's still a lot of talk about it, and the approval ratings are low enough where if you got a big enough majority in Congress and a motivated Congress, maybe something could potentially happen. Biden, just earlier this year, Justice Breyer announced his retirement. Biden appointed Justice Jackson to replace him. That doesn't change anything about the balance on the court. It just makes the left-leaning justices younger. But otherwise, there's still only 3 of them. Justice Thomas and Justice Alito are the 2 oldest members of the court now. They are staunch conservatives, and there's been some controversy surrounding both of them. Particularly lately, Justice Thomas, there's a lot of controversy around his wife and her involvement in January 6th and the efforts to overturn the election and stuff like that. That's kind of spilling out in ways where it reaches Justice Thomas. So a lot of controversy around him. He hasn't recused from certain cases where if your wife's doing that kind of stuff, maybe you should recuse from that, but he hasn't. Justice Alito has also triggered a bunch of controversy, which we'll talk about in a minute. We'll get to that. But a lot of controversy around the 2 oldest justices. They're not going to leave under a Democratic president voluntarily. So chances are the balance of the court's not going to shift anytime soon unless Democratic presidents are getting elected regularly enough that they are forced to leave involuntarily. So that's kind of our brief history of how we got to where we're at. We're at a new era of a Roberts court that is like the Warren court and is already in this last term, as we'll see as we talk about the cases, it's already started to show it's going to do the kind of stuff the Warren court did, only from the right instead of from the left. So all right, moving on to some numbers. The court used to decide almost 200 cases a term, 150 at least, and often approaching 200. In the early 80s, that number started to drop, and when Chief Justice Rehnquist was appointed as the new chief, he began to bring that number down more. The conservative side of the court tends to think that the court should do less, and so one of the ways they do that is by deciding fewer cases. That number came down to around 100 cases per term under Chief Justice Rehnquist. When Chief Justice Roberts took over, that number came down further to 85 or 90 cases per term, and over the past, I'd say 6 or 8 years, that number's been coming down even more to where it got down to where it was like 75. For the last few years, it's been around 65 cases per term. A couple years ago, it was 67, I want to say, or something like that, and that was the lowest number of cases that the court had decided since the Civil War. And they have continued to drop. This last term, they decided 64. So they're setting new records for the fewest cases decided since the Civil War over the last 2 or 3 years. The other thing that's happened this past term, it used to be over the last 10 years or so, about 43% of the cases were unanimous on average. In other words, you get a bunch of cases that aren't very controversial. They're not headline cases. Maybe it's bankruptcy procedure or something like that. And the court is actually in heavy agreement on a lot of stuff. 40% is a pretty high rate of unanimity, right? And that was the average, 40, 43, 45, maybe 39, right? Every year it was up there on unanimous decisions. This past year, we had 29%. Sudden drop. First full term with 6 strong conservatives on the court, and we immediately get a strong drop in the number of cases that are decided unanimously. It also used to be that about 25% of the cases were the split 5-4, where you had a swing justice that might go either way. It was really more like 20 to 25%. Some years it was 21, 22. But first full year of 6 staunch conservatives on the court, and we get 30%, a small rise in the number of ideologically split decisions in those closely decided cases. When I say 14 out of 19 cases polarized, that means it's the 6 conservatives, the 3 liberals. There were 5 cases where something maybe it was 5-4 because one of the conservatives joined the liberals, or maybe some other thing happened that made the split weird. But for the most part, 6-3 conservative versus liberal justices. Interesting to note that Texas was a party in a bunch of cases. Fifth Circuit decisions tend to be a bunch of cases. The Fifth Circuit's the one circuit in the country where the Supreme Court sometimes says we're not that conservative. The Fifth Circuit actually gets reversed by the Supreme Court for being too conservative sometimes, which is why a lot of Fifth Circuit cases get to the Supreme Court. As I mentioned, Roberts and Kavanaugh are the middle justices. They're not swing justices, but they are in the middle. They're the most moderate. They are the ones who, if you're going to a case, you're going to the court with a case where you think you're maybe on the liberal side of something, they're the two that you're going to most likely be trying to go after to get their votes because you're not going to get the other ones. Justice Sotomayor is sort of the out justice. She's the one that's dissented the most times this past term. That used to be in previous years, that used to be one of the right-wing justices. In the 70s and 80s, Justice Rehnquist was the out justice. He was way more conservative than the other conservatives, so he would dissent because he was saying the court wasn't doing things as conservatively as he wanted them to. In more previous years, it would often be Justice Thomas, who was the lone dissenter. He would dissent more than any other justice. Even though the court leaned conservative, he thought they should be more conservative, and he would dissent because they weren't doing things more conservatively. That has just shifted in the last couple years, where now, with a staunch conservative majority, now it is one of the liberal justices who's dissenting the most often, and it's Justice Sotomayor who's doing that. Justice Gorsuch is a lot like Justice Scalia, which includes he sometimes will swing over to join the liberals on certain kinds of cases, certain kinds of issues. He's not a swing justice in the sense where his vote split is, like Kennedy, it was sort of a 60-40 swing. Gorsuch is nothing like that. He's still 90% with the other conservatives, but there are certain cases or certain issues where he will surprise people and he'll join the liberals on something. We'll talk about one case in particular. Native American law is one area. He came out of Colorado, and the 10th Circuit handled a lot of Indian law cases, and he will often side with the liberals on those kinds of cases. So he can be a little bit of a wild card in certain areas. All right, so that's numbers, and now we'll start talking about cases. First big case we'll talk about is Bruen. This is the big gun rights case, which might have been the headliner case had it not been for another one that we'll talk about in a little bit. Bruen, so there was a case in 2008 called Heller, where the court, for the first time in history, recognized that the right to bear arms is an individual right that's not tied to the militia or anything like that. That happens in 2008. In that opinion, Justice Scalia says pretty clearly the right still might be subject to reasonable regulations or reasonable restrictions, right? So the question after Heller was, what's that going to mean, right? Okay, now this is a protected individual right. It has nothing to do with the militia, apparently. But according to the court, you can have reasonable restrictions. What will they allow as reasonable restrictions under the Heller decision? In this case, New York had a law that had existed for like 100 years, and it was a concealed carry law that required, it did not say you couldn't have a concealed weapon, but you had to get a permit for it, and when you went to get your permit, you had to show a special need for it. Maybe you've been facing a lot of threats from your ex, or something like that, but you have to show cause for why you need a concealed carry permit. And that's all it was. It was just, there's like a little bit higher bar for you to be able to have concealed carry. And this law gets challenged. Now that we have Heller and a bunch of stuff's happening at the circuit courts about gun restrictions, this case gets up to the court, and the question is, does that proper cause requirement for the concealed carry permit, does that violate the Second Amendment? Is that too much of a restriction on gun rights under the Second Amendment? The court, 6-3, says yes, it is. Second Amendment doesn't allow that kind of restriction. Justice Thomas writes the majority opinion. One of the big things about this case is we have seen the emergence of originalism as an approach, right? We're going to try to look at the original meaning of the Constitution and that sort of thing. But it's always been part of the argument section of these decisions. Thomas essentially builds originalism into the law with this decision. He basically says, a restriction, anytime a state or a local government or the federal government, anytime someone's trying to pass a restriction on guns where the Second Amendment is implicated, the authority that is doing that has to look to the history and tradition and the original meaning of the Second Amendment to see whether that restriction is the kind of restriction that might have existed at the time that the Second Amendment was ratified. And if it wasn't, it's not going to pass muster. Now, that seems different, right? That seems to create some problems, some hurdles for any gun restrictions, because they had no restrictions on assault weapons at the time that the Second Amendment was ratified, right? There's weapons that didn't exist. There's all kinds of restrictions that did not exist back then that we might want to exist right now, but Thomas says in the Bruen case, if they didn't exist back then, they can't exist now. So huge case on Second Amendment rights, huge case on gun restrictions, gun safety, that kind of stuff. Justice Breyer's dissent tries to point all of this out, like, hey, look at the number of gun deaths we have every year. Governments everywhere would like to try to prevent that, would like to try to protect public safety, would like to try to do something about these gun deaths, school shootings, all that kind of stuff. And what you've done here, in Breyer's dissent, he's saying what you've done here is going to severely handicap the ability to do anything about any of this. Justice Alito wrote a concurring opinion where he basically was aiming that concurring opinion at Justice Breyer and saying, so what? That's not our job. Our job is to say what the law is, right? Under the Second Amendment and its original meaning and stuff like that. All right, so huge case. Again, didn't quite get the headlines it might have gotten if there hadn't been another case that came out. We'll get to that in a little bit. We're going to talk about the First Amendment, religion rights. So there's a built-in tension, if you guys remember from your constitutional law class. You got the Establishment Clause and the Free Exercise Clause, right? There's a little tension there sometimes in some cases because states might want to not do certain things because they don't want to violate the Establishment Clause. But then by not doing those things, they may create tension with the Free Exercise Clause, because by not doing that, maybe it looks like they're actually impinging on free exercise. That tension between those two clauses has been around for decades. What happens in this case, what has been happening at the Roberts Court is it's getting harder and harder to violate the Free Exercise Clause, to violate the Establishment Clause. In other words, governments can do more and more in the realm of religion without violating the Establishment Clause, because the conservatives on the Roberts Court, they don't mind governments getting involved in promoting or endorsing or supporting religion, or even just allowing it in places where they previously weren't allowing it. So the Establishment Clause, you really can't violate it anymore. The Free Exercise Clause, it's hard to not violate the Free Exercise Clause at the Roberts Court. Just about anything a government does, if it touches on religion anywhere, the Roberts Court is going to take a hard look at that because they're very protective of free exercise rights. They don't care so much about Establishment Clause. So in the Carson case, Maine, the state of Maine, had this tuition assistance program so there are certain, I don't know if any of you have ever been to Maine. I lived in Maine for a little bit. There's a lot of rural area in Maine, a lot of small towns, and there are some school districts in Maine that don't actually have a public high school in that school district. It's just too small. It's too small to justify. They don't have the tax base to support a school, and it's too small to try to have a school for that many students. So there are some school districts that just don't have a public secondary school. So Maine implements this tuition assistance program for students in those kinds of areas where they can get state money to assist them with tuition to go to a private school because their area doesn't have a public school. But Maine doesn't want to run afoul of the Establishment Clause, so Maine says you have to go to a non-sectarian school, right? Like, we don't want to be supporting religious schools. That's going to be an Establishment Clause problem. So they have this tuition assistance program, but only if you're going to go to like a non-sectarian school. That gets challenged because we have this new Roberts Court. It's been a program that's been around for a long time. Everyone thought it was okay because of the Establishment Clause. This goes to the Roberts Court. Roberts Court says, nope, violates free exercise. Okay, so this is a big deal. The Roberts Court's been sort of chipping away at Establishment Clause protections, chipping away at that and expanding protection for free exercise rights. This is another case in that line of cases. The bigger case this year was the Kennedy case. Coach Kennedy was a football coach in Bremerton. And at the end of his football games, he would go to the 50-yard line and he would kneel down and say a prayer. After a while, the school started to get concerned about this. And the school started telling him, hey, we'd prefer you didn't do this because, once again, we're a little worried about some Establishment Clause problems, right? We're a public school. You're going to the 50-yard line right after the game to say a prayer while everyone is still in the stands and people are still around. We're starting to feel like this might be a problem for us and our liability when it comes to Establishment Clause problems. So they start warning him about it. Eventually, he refuses. He keeps doing it. Eventually, the school says, we're going to have to let you go because you're not listening to us. We're concerned. So that he gets fired. He sues, and the case gets to the Supreme Court. The question is, does restricting his ability to pray at the 50-yard line after football games violate the Free Exercise Clause? And the court, Justice Gorsuch writes the majority opinion. The court says, 6-3 again, this does violate free exercise protections. And Justice Gorsuch describes in the facts section that this is a private affair, right? He's doing something that is a personal, private thing. He's praying at the 50-yard line privately and personally. The school can't restrict that. That's violating his free exercise rights by restricting that. Justice, I think it's Sotomayor, but it could have been Kagan, I think it's Sotomayor, writes the dissenting opinion and includes this photo along with a couple other photos to say this is not a private affair. The reason the school started getting concerned about this is that the teammates and others on the field were joining the coach in these prayers. The press, you can see, there's a woman with a camera in the background. The press was actually showing up and covering these prayers publicly in the public newspaper. It wasn't a private affair. And Sotomayor is saying, what are you talking about? You're misrepresenting the facts of the case, right? This is a very public thing that's happening. There was some evidence that some players on the team felt some pressure to join in the prayer because the whole team's praying with the coach at the 50-yard line after the game. So big problems that weren't really represented in the facts. But nevertheless, the 6-3 majority, they can kind of do what they want, and they say this violates free exercise. An interesting aspect of the case, there was some question about whether the coach even wanted his job back when he sued. There was some question about does he really have standing if he doesn't want his job back? But that just sort of got swept aside. After this decision came out, all the press went and talked to the coach. He said, I'm thrilled. You know, my body's vibrating. I'm so happy. And months later, the school has said, hey, we know the court told us we have to hire him back, but he won't respond to our calls. He doesn't seem to want his job back. Nevertheless, this is the law now. There might have been a standing problem maybe, but we're just going to ignore that. All right, so that's First Amendment. Moving on. We do have one more First Amendment case. So campaign finance. The court in the late 70s issued its decision in Buckley, which basically says, you know, money's speech, so you can't do too much to restrict campaign speech and that sort of thing. But under Buckley, Congress has still managed to pass some campaign finance restrictions and said, you know, to try to sort of avoid what Buckley says about speech, campaign finance and speech and stuff like that. But the court has really pretty systematically, every time a campaign finance restriction has come up before the court has pretty much almost every time, stricken down that restriction as a violation of free speech rights. So it's been really hard to regulate money in politics. One of the restrictions that was passed is this restriction on post-election campaign contributions being used to repay a candidate's loan to his own campaign. So, you have, I'm running for office, I'm having trouble maybe raising money, or maybe I'm not having trouble raising money, but I want to give my campaign some of my own money. It used to be that there was a restriction that said, I can only repay myself up to $250,000 with post-election campaign contributions. And the main rationale for this is, look, when you donate money to a campaign candidate prior to the election, we can at least pretend that there's not any quid pro quo going on because you don't know if they're going to win, right? So you give them money, that doesn't necessarily mean they're going to do anything for you in return because they might lose the election. But post-election campaign contributions, you know if they won. And if they won, when you give them money, you have a greater expectation they might do something in return, particularly if you give them a lot of money. So the fiction that we like to live under, that there's no quid pro quo going on with campaign finance, that starts to dissolve and become problematic when we're talking about post-election campaign contributions. So this limit was, hey, we're not going to let you go out and get money from people after you got elected, right? That looks really bad. Senator Cruz, in the 2020 election, I guess it was, he loaned his campaign $260,000 specifically to challenge this restriction. And then after he won re-election, he immediately proceeded to pay himself back from his campaign finance donations. And the FEC came after him and said, hey, there's this restriction on the limit. You're paying yourself $10,000 more than what you're allowed to pay yourself. So Cruz challenges the restriction. This was, all Cruz and everybody else totally admits this was the plan, right? We are trying to trigger this case. So the case goes up to the Supreme Court, and sure enough, the Supreme Court 6-3 says, yes, this restriction violates free speech because money is speech, and you can't restrict speech this way. Justice Kagan dissents. Kagan makes this point about the quid pro quo problem. Like, the reason we have this is for this problem, and by eliminating this restriction, you create this situation where big donors, after you win election, big donors can help pay you back however much you loaned to your campaign, put money directly into your pocket, and there is this at least appearance of the potential for quid pro quo.
Potentially could be used by someone who's potentially running a few years to make a false loan to themselves. Just throwing that
Yeah, it might. I don't know. All I know is the restriction's gone. So that's the other big First Amendment case that came up that creates, again, more problems for trying to control money in politics. Next is the Fourth Amendment. This is weird. The court for years, I didn't go to try to count how many years, but I mean probably decades. For years and years and years, the court has had at least one, but usually 2 or 3 big Fourth Amendment cases, because there's a lot of open questions about different kinds of searches, different kinds of seizures, what exactly constitutes an unreasonable search, what are the exceptions to the protections against unreasonable searches and seizures. I mean, the Fourth Amendment is just a huge pile of open questions about how this stuff gets applied in the real world. They have had cases on the Fourth Amendment every year for years and years and years. Last year is the first year that I know of in I don't know how long where there's nothing. Nothing on the Fourth Amendment. And what's weird about this is so far this year, for this term, still nothing. The last time we had a Fourth Amendment case that got granted, the petition got granted where the Supreme Court's going to address that Fourth Amendment issue was 2020. So last year, nothing. So far this year, nothing. When we hit January, it's around the beginning, maybe close to mid-January, but it's really more toward the beginning of January. If a petition hasn't been granted by that time, it's too late to get it in for the current term because you got to have all the briefing and everything happen before June or July. So in another few weeks, we're going to hit that point where it's too late to get any more cases this term, and we still have no Fourth Amendment cases. This is really weird because not only are there a lot of open questions, there are a lot of circuit splits. There are a lot of, the law is different in some areas of the country than it is in other areas of the country because of the way the circuits split over these issues. So police can do things, they can do things in one area that they can't do in another area. Criminal defendants have certain rights in some areas that they don't have in other areas, and the Supreme Court's not resolving those splits at least this past year and a half. So really weird, worth noting. I don't have a case to point to because it's weird that we have no cases. All right, next on constitutional rights, Bivens. A lot of you might remember the Bivens case from law school, 1971, I think. Yeah, Bivens is a decision by not the Warren Court, but the newly emerging Berger Court, where the 1970s-style conservatives, at least, agreed with the liberals that if you have a right in the Constitution, that means, of course, you're going to have a remedy. You can't have a right without a remedy. So what Bivens basically says is, if your rights are violated, you have an action to sue for that violation of rights against the federal officer who violated your rights. You have that right of action. That's just part of your remedy for having a right. That's what it means to have a right. That's basically what Bivens says. Almost ever since then. Bivens survived just fine through most of the 70s, but beginning in the 1980s, as the court was moving more and more conservative, the court started chipping away at that and saying, well, it's only in certain situations. And the conservatives on the court have basically taken the position that the fact that the Constitution gives you a right doesn't mean you have a remedy when that right is violated. That's something Congress has to provide. Congress has to create a right of action to sue for the violation of your rights. In other words, the rights in the Constitution are not self-executing. Now, some of this comes from originalism. A lot of the originalists on the conservative side of the court, they believe that in the original understanding of the Constitution, you did have a pre-existing remedy. When the Constitution said you had this right, you were supposed to use state tort law to sue for the violation of your rights. So, for example, I have a state tort action for trespass, and if you come onto my property to search my property in a violation of my Fourth Amendment right, I can sue you for trespassing, right? And my trespass action under state law would protect my Fourth Amendment right. That's what some originalists will argue is how rights were supposed to be remedied under the original understanding of the Constitution. So that's why the rights aren't self-executing. They already had rights under state law, and Congress has to, if there isn't already a remedy, Congress has to provide one. So Bivens has been chipped away at for the last couple decades. This case comes up. This case is great. Mr. Boole, I'm going to pronounce it that way, owns this, it's called the Smuggler's Inn. And it is right on the border with Canada. Some might think this is just a playful joke. You know, we're just naming the inn Smuggler's Inn because it's by the border and that's just kind of funny. But maybe there's some evidence that there's some actual smuggling going on at this inn right by the border with Canada. So a border agent, a federal agent, comes to the Smuggler's Inn to ask some questions. And in the conversation with Mr. Boole, things get a little heated, and the federal officer actually knocks him to the ground and gets a little rough with him. And then when Mr. Boole finally sends him away, that federal agent goes back and calls up the IRS and sicks the IRS on him for an audit. So the IRS initiates an audit. Mr. Boole sues and says, you violated my Fourth Amendment rights with excessive use of force, right, which is an unreasonable seizure. So your excessive use of force is a violation of my rights, and then sicking the IRS on me is retaliation. I've got free speech. You know, you're basically retaliating me because of the things I said to you when you came and visited, and so it's a retaliation claim under the First Amendment. But the question is, does he have a right of action under Bivens? Because the court's been saying a lot lately about how Bivens doesn't really give you a right. Bivens is fine for very specific cases, but not for everything. The court says 6-3, no, you don't have a right of action under Bivens. Once again, reiterating that Bivens is just for very specific. Basically, what you have under Bivens is if you have the case that existed in Bivens, you have a right of action. If you're not bringing the case Bivens, then you probably don't have a right of action to protect your federal rights against federal officers. Now you do have, if it's state officers who violate your rights, you have Section 1983, right? Because Congress has enacted a statute that gives you a right of action against state officers. So Section 1983 claims exist, but if federal officers violate your rights, right now you have no action. Now the problem with the originalism approach here, which Thomas does invoke in this case, the problem is we have something called the Westfall Act. What the Westfall Act does is it says you do not have a state law right of action against federal officers. Well, if the originalist approach is your remedy for federal violations of federal constitutional rights is a state cause of action, but the Westfall Act says you have no state cause of action against federal officers, then you have no remedy for any constitutional right that's violated by a federal officer. And in this case, the parties representing, or the lawyers representing Boole, said, if you're going to say there's no Bivens action here, you need to address the Westfall Act. They challenged the Westfall Act in this case. They said, our first question is, does he have a right of action under Bivens? Our second question is, if not, is the Westfall Act unconstitutional because it leaves us without any remedy? And the court said, we're going to address the Bivens question, we're not going to address the Westfall Act question. So they just didn't even address it. So the result here is, again, unless you're bringing the Bivens case, you don't have any remedy right now for a federal violation of federal constitutional rights. You just don't. Until Congress decides to enact a statute that gives you a cause of action. You don't have it. Justice Gorsuch wrote a concurring opinion where he said, the only thing I don't like about what the majority did is they didn't just outright overrule Bivens. I think they just should have overruled Bivens. So that was his 2 cents, I guess, about it. In other words, you could still bring an action if you had the Bivens case, and I don't think you should even be able to do that. He just thinks Bivens is wrong. So, all right, moving on. Civil rights, this is statutory civil rights, right? You have your constitutional rights, and then you have rights that are created by statute. So things like anti-discrimination statutes, for example, that say don't discriminate based on race or religion or sex or gender or things like that. In this case, the Cummings case, this was, I believe, if I remember correctly, an primarily age discrimination case. So there were two statutes at issue, but they were statutory provisions dealing with age discrimination. I mean, I think the provisions probably referred to other things that you can't discriminate by, but age discrimination was what was at issue. And the question in the Cummings case was, can the person recover emotional distress damages for the discriminatory conduct that they are suing for? Now, this is a huge, huge question in the area of civil and constitutional rights, because a lot of times the emotional distress is the primary harm you suffer from whatever the discriminatory behavior is, right? Maybe you didn't lose your job, maybe you didn't get demoted, maybe you didn't fail to get hired, maybe it's not anything that could be monetized, right? Other than the emotional distress of facing this kind of discrimination week after week at your job. So lots of civil rights cases make a claim that there's a serious emotional distress from whatever the discrimination is that they faced. The question here is, do they get that kind of recovery in these kinds of cases? The court says 6-3, no. That kind of recovery is not available in statutory civil rights cases, at least not in these statutes. This is going to trigger other litigation about other anti-discrimination statutes and what remedies are available. But what Roberts points to is history and tradition, which is we're not talking about the Constitution, so it's not quite originalism, but it's like the version of originalism that we're going to use when we're talking about statutes and other things that aren't the founding fathers. But he points to history and tradition. He says, look, these statutory protections against discrimination, they're sort of like contracts. It's kind of like we've created a contract with the employee that they won't be treated in certain ways. And under history and tradition of contract law, emotional distress damages aren't available. So because of that, we're going to say they're not available in these kinds of statutory actions. Justice Breyer writes a dissent saying, hang on a second, there's actually a whole section of contract law where there's a big history and tradition of getting emotional distress damages in contract law when it's dealing with certain kinds of contracts that provide certain kinds of protections. So under your own history and tradition argument, we could be looking at this and saying there is a history and tradition of emotional distress damages in contract law, if you're going to analogize this to contract law, where these damages are available. But Justice Breyer has only 2 other justices who will agree with him on the court, so 6-3, these damages are not available. Huge, huge decision for civil rights law, mostly because it's going to be expanding out into other statutory rights and whether or not these kinds of remedies are available in other contexts beyond the age discrimination under these particular statutes. So another huge case. A lot of these cases, by the way, are huge cases that just don't get the headlines because of the 1 or 2 other cases that get all the headlines. This was another huge, huge, huge case. This is one of those Indian law cases I was talking about earlier where Justice Gorsuch will sometimes swing over with the liberal justices. 2 years ago, Justice Gorsuch actually wrote the majority opinion in McGirt. I don't know if you remember. I'm sure I talked about McGirt the last time when I did this presentation. McGirt basically says, so in McGirt, an Indian criminal defendant had been prosecuted by the state in a state criminal proceeding, but the crime happened on land that had historically been Indian tribal land, but the state had they hadn't really, the protection of that land as tribal land hadn't really survived time. So over time, the state had kind of taken land little by little without any change to the original treaties. And so the reservation land, the Indian land, had shrunk over time. So when this crime was committed, it was committed on state land as it was currently understood, but historically under the treaties, it was Indian land. And there's a long history of where the tribes and the federal government have joint jurisdiction over Indian land, but the state has no jurisdiction when it comes to Indian land. That's the centuries of Indian law says federal government has joint jurisdiction because they have these treaties with the Indians, but states have no jurisdiction. So McGirt, who gets prosecuted by the state, he challenges his conviction and says, you prosecuted me for something that occurred on what should be Indian land, and you had no jurisdiction to prosecute me. And Justice Gorsuch in McGirt writes the majority opinion that says he's right. The treaties were never changed. Congress never passed, the US Congress never passed any kind of legislation to take any of this land away from the Indians. Basically, half of Oklahoma should still be Indian land, but it's been taken away from the Indians by Oklahoma. That's not how this works. If you want to change things, you have to change the treaty, you have to change the statute. Under the treaty and the statutes as they're written, this is Indian land and the state has no jurisdiction. That's McGirt. Huge decision in Indian law. Huge, huge, very important decision. Probably the case that would have been cited for the next couple decades in every Indian law case that ever arose. But what happened between McGirt and Castro Huerta is Justice Ginsburg died. And Justice Ginsburg gets replaced by Justice Barrett. And now Oklahoma challenges what happens in Castro Huerta is he is a non-Indian in a crime against an Indian, but he gets prosecuted by the state. He challenges his prosecution under McGirt. He says, hey, this was on Indian land. You didn't have jurisdiction to prosecute me because this is Indian land. And Oklahoma says, whoa, McGirt caused all kinds of problems for us, right? We've got all these like decades of convictions and other kinds of stuff. Everyone's filing habeas cases everywhere because McGirt just threw everything into a, bee's nest of craziness. So Oklahoma goes to the court and says, you gotta change this, right? You have to change this. This can't be right. 5-4, Justice Kavanaugh writes the majority opinion. Gorsuch writes the dissenting opinion with the other three, not the other three, he's not one of them, but with the three left-leaning justices. Gorsuch joins them, says, hey, McGirt was totally right. You are totally wrong here. But he doesn't have 4 liberal justices to join him anymore because Ginsburg is gone and now Barrett has replaced her. And Kavanaugh's opinion says, and there's a careful distinction here, so it used to be centuries of tradition, any case involving Indians. If Indians were involved and Indian land was involved, the state had no jurisdiction. Federal government, tribal government, they have joint jurisdiction, no state jurisdiction. Centuries of established law. What Kavanaugh says and the majority says is, this was the prosecution of a non-Indian in Castro Huerta. And he says, in that kind of case, the state has joint jurisdiction, even though it happened on Indian land. And he says, in fact, any state would have joint jurisdiction over what happens on Indian land. So this is not just limited to Oklahoma. Suddenly, nationwide, every piece of Indian territory is now under the state's joint jurisdiction for criminal cases, as long as the defendant isn't an Indian. But it can involve Indians. It could be a crime against Indians. It can be a crime against the Indian land, on Indian land. It can be anything else, but as long as the defendant is a non-Indian, the state now has joint jurisdiction over all Indian lands nationwide. Absolutely earth-shaking, groundbreaking, monumental decision in Indian law. Nobody really knows about it, right? Like probably none of you heard about it until today. Big case, just 2 years after McGirt. By the way, under McGirt, under a sort of straightforward reading of McGirt, this should not happen. But that sort of careful distinction and a new majority on the court, and that's what you get. All right, the next case, administrative law. This is another huge case. Again, did not get a lot of mainstream attention. So there's this thing called the non-delegation doctrine. It used to exist sometime in the distant past where there was this idea from the conservative side of the court. The idea was that Congress could not delegate legislative power to executive agencies. That non-delegation doctrine basically says only Congress can legislate. You can't create an agency from the executive branch and then Congress give that agency the ability to make regulations or rules. That's legislating. That's Congress's job. That non-delegation doctrine died something like 80 or 90 years ago. The court rejected it, said that's not right. Obviously, they had to have done that because we have things like all the agencies that we have and all the regulations and rules that they create. So the non-delegation doctrine has been dead for decades. This case sought to resurrect it. What this case was brought as is a challenge to the administrative state as we know it. They wanted the court to embrace the non-delegation doctrine and say you cannot delegate to agencies the ability to make rules or regulations. That is Congress's job. Non-delegation doctrine wins. Basically, everything, the way the government works as we know it, has to be completely undone. That is what this case was supposed to be. Everyone was really worried about it. What ended up happening is Chief Justice Roberts writes the majority opinion, and instead of the non-delegation doctrine, which he does not outright reject, but instead of relying on it, he relies on what is called the major questions doctrine. Now, this is a completely court-created doctrine, which usually the conservative side of the court doesn't like. But in this case, they said, we're going to say, under the major questions doctrine, what the major questions doctrine basically says is if Congress is going to give the agency authority to do something about major questions, big things that have nationwide reach or whatever it is, that's part of the problem with the major questions doctrine is we don't know what actually qualifies as a major question. It's basically anything that the court says is a major question is a major question. That's one of the problems with court-created doctrines. The courts get to say what they mean. But under this major questions doctrine, if Congress is going to give the agency power to do something about something that is a major question, then Congress has to be super specific about what exactly the agency can do. And in this case, the EPA has authority or had authority to promulgate regulations capping emissions or doing other kinds of things, dealing with the environment, climate change, that kind of stuff. And the question was, does the EPA actually have the authority to do this? And the court says, no, they don't, because this is a major question, whether the agency can control the economy and the environment in these kinds of ways. And the Congress was not specific enough, so this is the other part of the problem. We don't always know what a major question is, and we don't always know how specific is specific enough. But Congress has to be really specific if it's a major question, or else the agency doesn't have authority to do whatever the agency is trying to do. So EPA loses authority to promulgate these regulations about capping emissions, and we're going to see a whole bunch of other cases challenging agency regulations and the agency's authority to pass those regulations under the major questions doctrine. And any agency power that the Roberts Court doesn't like is probably going to be a major question where the Congress was not specific enough about what the agency can do.
Jason, do you think that will also apply to, some agencies actually issue decisions, thinking about the National Regulation Board, that it could actually impact that also for their decisions?
That's a good question. I don't know. My guess is that you probably would have to come at it through the regulation that the decision is about. So you might challenge the decision, but you would challenge the decision by saying the regulations this decision is based on are actually not, the agency actually doesn't have authority to have passed those regulations in the first place. So they certainly don't have authority to issue the decision about it, right? That's my guess is how you probably have to go about it. But that's an interesting question. All right, another huge case. Again, it's not the kind of thing that grabs the headlines, but really big deal. This was I feel like every year lately I've been saying this is a monumental term at the Supreme Court. This one, I've been saying that every year for the last several years. This one really is. This is really, I mean it, guys. Anyway, huge. Justice Kagan's dissent basically tries to explain what's wrong with the major questions doctrine and how this is going to create havoc for the administrative state and agencies and what they do. And again, she's only got 2 other people to join her on that. All right. Whoops, I hit the wrong button. Last but not least, you guys probably heard about this one. So, quick history about Roe and Casey. Roe, many people do not actually know, Roe versus Wade was not actually a very controversial decision when it was issued. It was decided 7-2 by a burger court that now had 4 new conservatives on it from President Nixon. Only 2 justices dissented, and that included Justice Rehnquist, who was perceived when Justice Rehnquist was nominated by President Nixon, one of his own aides said, "Are you sure? Because this guy's farther right than Pat Buchanan." Rehnquist was perceived as the right-wing, far right, how are you possibly nominating this guy? But Nixon had 4 seats to fill and felt like he could get away with it, and he did. And so Rehnquist got onto the court. Rehnquist was one of the 2 dissenters in Roe versus Wade. I can't remember who the other one was, but there were only 2, and it was not very controversial at the time that it was issued. It was not until, it was issued in 1970, does anybody know? 73? So it's issued in 1973. It's not until getting more into the mid and late 1970s as there's a new emerging, what gets called, this is a new moniker, right? Nobody's heard this term before until the late 70s, the religious right. It's really interesting, actually. The reason it's called the religious right and that term takes hold is previously, in prior decades, most people who were pretty religious actually tended to lean left politically. They favored welfare programs that helped the poor and the elderly and stuff like that. That was sort of the religious mentality. More liberal-leaning politics were supported by most more religious thinking people. So the concept of a religious right was kind of a new thing. That's why when it got labeled the religious right, that label stuck, because that was what? Religious right? But with the rise of the religious right in the late 70s, mostly initially in opposition to the Equal Rights Amendment that was being pushed in the mid to late 70s, that was where a lot of the opposition was aimed, but they also started looking for other things to attack, and one of the things they pulled out was Roe. So in the mid to late 70s, Roe starts becoming really unpopular several years after it had been decided. Through the 80s, Reagan appoints Justice Scalia and Justice Kennedy, who at the time, he believes Justice Kennedy is a staunch conservative like Scalia is. Later, Bush Sr. appoints Justice Thomas and Justice Souter. He believes Souter, everyone believes Souter is a staunch conservative the same way Thomas is. So they now think, the conservatives on the court and the conservatives in the political world, they now think they have the majority now to overturn Roe versus Wade after spending the 80s talking about how bad Roe is. So with Kennedy and Scalia and Souter and Thomas, plus whoever was still on the court at that time, they feel like we've finally got at least 5 justices to overturn Roe. And that's what brings Casey up. Right, it's 1993, 4, somewhere in there. 94? Hey. So Casey comes up in 94, and everyone thinks this is it. We're getting rid of Roe. But O'Connor was still on the court, and she's that swing justice. And then it turns out Kennedy and Souter are not quite the staunch conservatives that everyone thought they might be, and they join O'Connor to basically save Roe with the Casey decision. Now, with the new Roberts Court and a strong 6-justice majority, and by the way, before Barrett gets onto the court, we still have a strong 5-justice majority, and now they have this new vetting process, right? They're not letting any more Souters or Kennedys onto the court. They're going to have staunch conservatives and only staunch conservatives. So we've got at least 5 when this case first starts getting going, and then we get 6 by the time the case gets to the court. Now they think we're really going to finally get rid of Roe, and they do. Justice Alito writes the majority opinion. Roe and Casey are overturned. There is no constitutional right to abortion. Huge victory for the decades-long fight for the conservative side of the court. It's interesting to note, well, first of all, I'll note originalism, again, plays a big role in all of this. I will note, along with that lots of bona fide originalists in the legal academy who are conservative originalists say that the originalism in this opinion is terrible. It is not strong originalism. It's received a lot of criticism even from conservative originalists. But one of the things that the court says is we are bound by the stuff that the parties present to us. So originalism is the right way to go, but we're limited by what originalism is presented to us by the parties. This is a kind of weird thing because that means the parties can present really bad originalism and the court can rely on that because originalism is what they want to rely on, even though it's not right historically, because they're going to only rely on what the parties present. That's a footnote by Justice Thomas, by the way, if you want to look it up. He basically says, yeah, we got to go by what the parties present us. So that's the 2 cents about originalism. Chief Justice Roberts and Justice Kavanaugh write concurrences, and they try to make it really, they don't try to make it clear. It seems clear from their concurrences that the 2 of them may have been willing to strike down the laws in this case without overruling Roe and Casey. That is interesting because you guys heard about the leak, right? So this opinion was leaked a couple months before it was actually issued by the court. There are a lot of people who believe that the motivation behind the leak was to try to prevent Roberts and Kavanaugh from swinging over with the liberal justices to say, we might strike down these statutes, but we don't have to overrule Roe and Casey. So in order to sort of secure the majority for overruling Roe and Casey, the opinion was leaked to say this is where the court is, and now if you change your mind, you're going to look like, you're chicken or something like that. A lot of people, that's the theory behind the leak. A lot of people don't think that's the theory behind the leak. They have other theories. We still don't know who the leaker is, although a lot of people think it might have been Justice Alito or his chambers. Again, other people have other theories.
There is no credible evidence.
Nobody has evidence of anything. Yeah, there's just different theories about what might have happened. The only reason I mentioned that theory is because it has just recently come to light that Justice Alito may have leaked the Hobby Lobby decision to other people that he went to lunch with and stuff like that. Right. I understand.
In fact, they have flatly denied those conversations.
Well, some of the people are no longer around who were involved in the conversations. But
Those people are alive. They've been interviewed, and they've all confirmed that conversation did not happen.
fair enough. But all I'm saying is these are the theories floating around. Yeah, all I'm saying is these are the theories floating around. When I mentioned earlier that there's been a lot of controversy about Justice Alito lately, this is what I'm referring to. There's been a lot of controversy. Justice Thomas has faced a lot of controversy because of his wife's activities. Justice Alito now has been facing some controversy because of all of this stuff. The people speculating about him leaking the Dobbs opinion, and then people speculating about him leaking maybe the Hobby Lobby decision. We don't know. Nobody knows. We don't have any outcome about the court was supposed to be investigating the leak. They said we're going to investigate. We're going to get to the bottom of this. This is a really big deal. We still don't know. We don't have any kind of result, any kind of announcement from the court about any of that. Nobody knows anything. But that's the controversy that's going on surrounding Dobbs and surrounding Alito and all that stuff. Huge, huge decision, by the way, as we've already seen. I just read this morning. This is an interesting potential piece of the fallout from all of this. President Biden is the first president since FDR to hold every seat that the sitting president had in the Senate in his party without losing any seats. First time since FDR that's happened. Every single midterm election under every single president, the sitting president's party has lost at least one seat until now. And there are people who speculate that a big part of it was the backlash against the Dobbs decision. Don't know, right? We don't know if that's why, but it's interesting. It's possible. Huge decision, obviously the biggest headline-grabbing decision of the term, to go along with a bunch of other really big decisions this past term. Whoops, hit the wrong button again. All right, so coming up this term, we thought like this is there's been a bunch of monumental terms. This is the real monumental term. They're not done, right? There are big cases coming up this term. They've already heard oral argument in a bunch of them, not all of them, but affirmative action. Everyone sort of assumes affirmative action's on the chopping block. That is going to go away. There are 2 cases before the court right now dealing with affirmative action. If oral argument is any indication, affirmative action's probably gone. The Indian Child Welfare Act is another big Indian law case where this is a statute that essentially says that there's a priority, a federally imposed priority for placement of Indian children in adoption to try to put them with Indian family members or tribal members in order to preserve the longevity of the tribe, rather than having them adopted out to non-Indian families and sort of losing that connection to tribal identity. The challenge to it is that is that's a racial discrimination, basically. I mean, there are other challenges wrapped up in there, but that's kind of the central one. But the argument against that is this is not about race. This is about treaty and statutorily recognized political organizations, which is what tribes are, who have sovereignty and they have a political existence. And so this is really about a political identity and preserving that rather than any kind of race-related kind of thing. But that's one of the cases actually that's come out of the Fifth Circuit. Fifth Circuit issued a decision that was very controversial about a bunch of the issues in that. The Supreme Court's now dealing with that. Section 2 of the voting rights and gerrymandering is also up there. Right now, Section 2 of the voting rights is the only section left in the Voting Rights Act that can be really used with any kind of teeth to it for challenging things like gerrymandering and other voting restrictions. It's the only piece of the Voting Rights Act that's left, and everyone is thinking it's probably not going to be after the end of this term. Other kinds of stuff, I won't go through the rest. The other big one is the independent state legislature doctrine. I actually think that was today they were hearing oral argument on that case. That's a huge case because it could fundamentally change I'm not going to do this justice, but the basic idea is that if the state legislature passes any kind of voting law in the state legislature is independent in doing that under the federal constitution, and the state court cannot review it. So if the Texas legislature wanted to restrict voting in some way, the Texas Supreme Court could not review what the Texas state legislature did. That's huge, right? Because under the sort of traditional way that we think of checks and balances, the state court ought to be able to review what the state legislature did. Under the federal protection of voting rights, seems like there ought to be some protection there, but big case. People are not, I think that people are split on whether they think the court will really embrace that doctrine. I think a lot of people are worried they will, but there are also people who think they're not going to go that far. But we'll see. They got 6 justices, so. That's it. That's all I got. I think we're out of time. Any questions?
Quick question. On the affirmative action case that's on there, is that challenging something like this as like a university quota type system, or is that challenging another federal statute? What's the challenge?
There are 2 cases. One's Harvard and one is the University of North Carolina. So it's a state university and a private university. So there are some slightly different issues, but both cases are basically straight up challenges to saying affirmative action is an unconstitutional race-based preference. And so if you have race-based preferences in these affirmative action programs, it would wipe out any affirmative action program as we know it. I'm sure there are going to be places that try to still do something that gets around whatever it is they're saying you can't do, but it really, affirmative action as we know it would not be available. So, any other questions? All right, thank you very much for having me. Have a good day.